Appeal for the 5th District, State of Florida is now in session. David Monaco, Chief Judge, presiding. All things and business for this court are on your given attention and you shall be heard. May God save the United States of the Florida and the power of the court. You may be seated.
Good morning and welcome to a session of the 5th District Court of Appeals. My name is David Monaco, as you've heard. I have the privilege of being the Chief Judge of this court. And serving with me on the first two cases today are, to my right, Judge Tom Sawaya, and to my left, Judge Richard Orfinger. We have a total of 3 cases scheduled. We'll have to have a change of panels with the third case. So what we'll do is we will consider the first 2 cases, then take a break, then consider the third case. The first case is a criminal case. Both cases are criminal cases. Each side will have 15 minutes per side. If the appellant wishes me to remind them of the amount of rebuttal time they have, please let me know that at the beginning of your argument, and I'll set the clock to that effect. The clock, you'll be able to read the clock without too much trouble. Having said that, let's begin with the first case, Wayne Russell SIEBOLD versus State.
Good morning, Your Honor. I'm Greg Eisenmenger on behalf of Mr. SIEBOLD. I would ask the court to remind me when 5 minutes is left in my argument.
Okay.
Your Honor, as our brief clearly established, what we believe the key issue in this case is the statutory interpretation of what was meant by right to be in the premises. The trial court summarized its position essentially as saying that Mr. SIEBOLD and Mr. Barnes, an invitee, someone that was invited by Mr. SIEBOLD's estranged wife, had an equivalent right to be on the premises. I would assert to the court that an invitation is not a right. It is a privilege. A privilege that can be revoked, as it was in this case, by Mr. SIEBOLD.
So Mr. SIEBOLD can revoke the privilege extended by Mrs. SIEBOLD to her guest?
Yes, sir.
In a jointly owned house?
I believe that he can. I believe that either person that is in equal possession of the home should be in the possession to revoke an invitation of another person. The best example I can give you for that, not having been...
What about the right of the person that made the invitation to have their guests stay in the house?
Again, an invitation is a privilege, and I don't believe that the...
but the person that made the invitation has a right to have their guests stay. You're saying that it seems to me that you're saying that the other joint owner has the right to revoke that invitation, and that trumps the other joint owner's right to have a guest in the home. I
would say if there's a dispute in that manner, I would. Yeah. Yes, particularly in this situation.
You're about to give an example. What was that?
Yes, sir. The best example that I can give is a situation where, for example, my adult daughter who lives with me invites guests over to the home.
Lives with you or owns the home?
Lives with me.
She doesn't own the home?
Does not own the home.
You own the home.
Mrs. SIEBOLD, or at that time, Mrs. SIEBOLD did not own the home either. Mr. SIEBOLD owned the home. She was there to protect whatever marital interest she had pending a divorce. But the owner of the home, and ultimately the person to whom the home, because of the superior prior interest in the home, was Mr. SIEBOLD.
Where is that in the record? Because we looked in the record to see who owned the home or who had a superior right in the home, and I couldn't find it anywhere in the record that was established.
I'm not sure that it was established. I did not try the case on the trial court level. I likewise looked for that in the record when I did the appeal. I know that because of my representation post and one of the things that I investigated in that. But I would agree with the court that the record is not clear on that particular point. There is testimony by Mr. SIEBOLD about it being his house and things of that nature, but it was not clearly established that he was the owner of the home, and that and again, I keep calling her Mrs. SIEBOLD. She actually is referred by her maiden name in the record because she still used her maiden name. But as I said, she was protecting what she believed to be an interest, and you had a situation that I'm told, I don't do a lot of divorce work, is all too common these days, where estranged spouses are remaining in a home until the court decides temporary custody, a situation that, again, I believe is highly volatile, and one of the reasons that I would assert that when you have that situation and you have even people who are equal in standing, and someone has invited someone over, and another person equal in standing objects to it, that the better rule would be that the invitee needs to leave in that situation. Because, as I said, it is a privilege. I cannot imagine coming home and my daughter inviting someone over, having a party in my home, being in my home and telling someone to leave, and being told by that person that I was invited by your daughter, I'm not leaving and you should leave, which is exactly the situation Mr. Siebold is confronted.
Isn't this statute really intended to apply to cases where an intruder or someone uninvited by anyone either breaks into the house or intrudes into the house and attempts to harm the people inside, or attempts to kidnap or remove somebody from the home? Isn't that basically what the statute was intended to?
No, sir. I don't believe the statute is tied to the issue of forced entry. I believe that you can look at it similar to a burglary statute, where you have someone who may lawfully enter a premises but because of their conduct while they're there, unlawfully remain. And that's the situation we had.
It could apply in that situation too, but it doesn't apply where you have two joint owners. Does it even make sense it would apply when two joint owners are involved in a dispute and one joint owner has invited a guest and wants the guest to stay, and the other joint owner objects and wants the guest removed? Doesn't it make sense to say that it wouldn't apply in that situation?
No, sir. I don't believe it does make sense, because I think that the position in that is that the owner of the home has a superior right than an invitee. An invitee does not have a right to be on the premises. He has a privilege to be on the premises.
Let's assume you're right. Does that mean that physical violence can be used to remove the person?
In the face of physical violence, and that's again what Mr. Siebold was faced in this particular case. This is not only Mr. Siebold first asked this gentleman to leave, then had difficulties with that, went back into his room for a period of time. Only when his now ex-wife continued to have problems with his request, came back, indicated to them the party was over, called 911, and then was physically accosted by someone who is much larger than he was, much more physically able than he was. As the record reflects, Mr. Siebold has a number of physical ailments as a result of an automobile accident. He is not able to protect himself against someone who is taller, heavier, and far more able, and who's being aggressive in this situation. Mr. Siebold characterized he was being physically accosted by this gentleman. He was pushed by this gentleman.
Let's focus on the statute for just a moment.
Yes, sir.
Because for the presumption to arise, before we even get to the exceptions, the presumption arises when the person against whom the defensive force was used was in the process of unlawfully entering or had unlawfully entered the dwelling or residence. And then we'll stop there for a minute and then go on to the or. You would agree that that part of the statute isn't applicable here. This
had not risen to that level.
Hmm?
It had not risen to that level at that
Okay.
point.
So now we go to the or, if that person had removed or was attempting to remove another against that person's will. Now, is it your contention that when Mr. Siebold tells, I forgot the gentleman's name.
Larry.
When he tells him, you need to leave, and the person who got hit with a baseball bat says, no, you need to leave, that when Siebold was told, no, you need to leave, that was an attempt to remove him against his will?
When you can hold that in conjunction with the fact that he's being pushed at that point, and he's being pushed and he said, no, you need to leave, yes, that's an attempt to remove Mr. Siebold from his own residence against his will. That is a guest attempting to remove him, throw him out of his house because his wife, who he is estranged, has invited this person and said, no, we're staying, we're continuing the party, you need to leave. Mr. Siebold, you're being removed from your own home. Yes.
Well, if you all wanted a jury instruction that was premised, it seems to me that if your argument has any legs, it has to be premised on the idea that Mr. Siebold has some superior interest in the property to Mrs. Siebold and her invitees.
I would agree that that would have been a better way to present the
So
facts.
doesn't it seem to me that you would have to offer some evidence that would demonstrate his superior interest in the property to be entitled to that assumption? Because the general notion of property law is that if you and I own a parcel of property together, we both have a co-equal right to use it and enjoy it as long as my use and enjoyment doesn't interfere with yours and vice versa.
I would agree with that.
So to be entitled to that jury instruction to begin with, wouldn't you have the obligation to demonstrate a superior interest in the property?
I would believe that in this particular case, a superior interest in the property is demonstrated by the fact that you have an owner versus an invitee.
Well, but again, your contention would be that if you and I own a piece of property together, and I invite Judge Monaco over, as unlikely as that might be, you don't like Judge Monaco, which is understandable, and you tell him to get out, that despite my request, oh no, stay, please stay, that he has to get out or risk being hit over the head with a baseball bat.
No, sir, I don't believe he... Thank you. I don't believe he needs to be risked by being hit over the head, but if I ask Judge Monaco to leave, I go to the point of calling the police to ask Judge Monaco to be removed. And at that moment in time, Judge Monaco physically accosts me in my home and tells me to leave. Then, yes, I believe that there is a risk of violence to me. And again, in the totality of the circumstances, Mr. Siebold arming himself with a baseball bat is something that is understandable. So again, if it's just a matter of Judge Monaco being politely refusing to leave, and we call the police and we wait for the police to come and arbitrate this, that would be one thing. But when Judge Monaco has already been verbally abusive to me in my own home, that you are adding to that abuse and stirring up the pot, so to speak, by your reaction to this. It's an estranged situation in the first place. And after I go to the act of calling the police because I do want you removed, and I do express in the 911 call that I am concerned about my safety, I am then physically accosted and asked to leave or told to leave my own home. Yes, I believe I have a right to defend myself. And I will reserve. Thank you.
If I had a nickel for every time that's happened, I'd be happy.
May it please the court, my name is Douglas Squire and I represent the state, the appellee. The state has nothing to add to its brief. If this court has no questions, we would ask you to affirm the conviction and sentence.
Yeah, I have a question. Assuming that Larry, the invited guest, began bumping Mr. Siebold first, what reaction, other than calling 911, which Mr. Siebold did, what other reaction would you expect from him? What was he supposed to do with this guy telling him to get out of his house?
Well, as outlined in the brief, he was entitled to defend himself. I mean, he was given the self-defense instruction. This was a guest, and there is no establishment of who had primary ownership or any deficient ownership. She had the right to have him there. And even if that was revoked by Mr. Siebold, then becomes a trespasser. And there's no presumption of deadly force or entitlement to deadly force against a trespasser. This was just two guys. And to even get to that point, there's no removal. As I cited a case, I mean, that was clearly intended for carjacking, kidnapping. To remove is to move by taking away. Nobody was taking Mr. Siebold anywhere. They were both asking each other to leave or ordering each other to leave, and neither one had the right to do that.
Thank you.
Again, the primary problem we have with the instruction that was given and why we feel that it misleads the jury is what was given is if the defendant is in his dwelling, he's presumed to have held a reasonable fear of...
Well, excuse me, the trial judge thought opposite. The trial judge thought that giving the instruction would mislead the jury. Here's what the trial judge said, and I simply believe on the facts of this case, Mr. Barnes and Mr. SIEBOLD had an equivalent right to be there. I think it misleads the jury to attempt to give them a presumption instruction on SIEBOLD attempting to defend himself against being removed from his own dwelling.
I understand the trial court's position. I respectfully disagree with that. But when you give an instruction that focuses on forced entry into the home and ties Mr. SIEBOLD's right to defend himself on his reason to believe that forced entry had occurred, when there was never an issue of forced entry, that the evidence clearly showed that Mr. Barnes had entered it pursuant to invitation, then that's misleading, confusing the jury.
Is there any evidence in the record that SIEBOLD was the one that was being removed from the premises?
Yes, sir. It's his own testimony, as I've indicated, that he was bumped and he was ordered to leave his premises. That was his testimony. Whether you choose to believe it or not, he's entitled to an instruction that explains his defense. He asserted, and it is a fact in his testimony asserted, that he had been physically accosted and that he was being told to remove himself from the house in the face of this physical act. And that's simply when he resorted to force. So yes, there is evidence into that, and he's entitled to an instruction that explains to the jury. Not an instruction that ties it to force entry, because that presumes in the jury's mind that he has no right to defend himself unless there's forced entry. And that's the problem in this case. He has the right to defend himself when, after someone has lawfully entered the home, they unlawfully remain, and through their actions revoke that privilege. As I'd indicated earlier, I believe that an invitation is a privilege. Not only can it be revoked affirmatively, but I also believe it can be revoked by the actions of the person while they're in the home. And Mr. Barnes' actions against Mr. SIEBOLD certainly revoked any privilege he had to remain. In the face of calling 911 to physically accost Mr. SIEBOLD, who certainly had a superior right to Mr. Barnes in any stretch of the imagination, and to order for Mr. Barnes to order Mr. SIEBOLD out of his home, certainly creates a fear in Mr. SIEBOLD's mind that he is being removed from his home. I believe he's entitled to respond with reasonable force in that situation. But more importantly, I believe that the jury is entitled to an instruction that explains his theory of the case. They still would be free to believe that it was not reasonable, but he was faced with that situation, and he did have the opportunity to respond. Thank you.
Thank you, counsel.